In the matter of Hamilton Road Ltd versus Claude Miller, file number 23-01344 LT, counsel appearance.
Gene Turnwald, Your Honor. Oops.
Your Honor, for the record, Darwin Fair on behalf of the defendants, P31266.
Gene Turnwald on behalf of Hamilton Road Limited.
Okay, today was the date set for an objection to entry of order under the 7-day rule. And Mr. Turnwald, did you receive the defendant's objections?
We received the objection and we responded. It's our position the objection is inappropriate. We asked that the court sign the order as submitted. He has not provided.
Because I don't have it in my file. When did you respond to the objection?
November 29th.
It's not in my file. Please state on the record the reasons why you or what your response relied on as to why his objections are invalid.
It's inappropriate to argue about an order that hasn't been entered yet. The proper form in objection to the entry of a 7-day order is for Attorney Fair to submit a substitute order and state why the substitute order is somehow more accurate than the order that's been proposed for entry. He wants to argue the case, argue the merits of the order when the order hasn't been entered yet. First, we enter the order. Then if he has an objection, to file it. And his objection, by the way, is entirely inappropriate. He seems to mislead the court, or at least intended to, was our perception, that he didn't know of the hearing when he knew perfectly well the hearing. In fact, his office contacted our office and told us when the hearing was. He entirely knew about the hearing, and his complaint appeared to be that he didn't get a written notice of the hearing date. But be all that as it may, we submitted an order under the 7-day rule. He has not submitted a substitute proposed order. Once that order is entered, then and only then he can file an appeal or a motion for reconsideration in regards to the order that's been entered.
Mr. Fair?
Well, Your Honor, I'm sorry.
I'm not gonna engage in the back and forth with you and Mr. Turnwald because I didn't have his response. I wanted him to put his reasons on the record. But my first concern or question is, why didn't you appear?
Okay, well, and Your Honor, if you didn't get his response, then you didn't get my response to his response. But direct answer to your question is that, number one, my office did not get written notice. Number two, Mr. Turnwald makes reference to a conversation between my office and his office. And my office characterizes the conversation a little different. Judge, only thing I can tell you, when it comes to motions for reconsideration, we can't answer a motion for reconsideration until we have an order. My office routinely checks the register of actions to see status of the case. When they saw that, they assumed that it was a control date because they hadn't seen an order allowing me to reply to the motion for reconsideration. And so that is the reason they called to see if there was an order. And Judge, I can tell you.
Did the register of action say it was a control day?
I don't know, Judge. I didn't look at the date, but Judge, let's assume.
It stated it was a hearing. Not only did it say it was a hearing, we have evidence in our file that clearly states that written notice was mailed to your office on November 9th of a hearing date on November 21st at 2 p.m. I did not order you to respond because I ordered you to appear in lieu of a response.
Okay, and Judge, I believe you. I did not, as an officer of court, I did not get it. And if I had gotten an order from this court saying I could respond to a motion for reconsideration, I would most certainly have done that.
I didn't ask for any response. I asked for an appearance, and I sent a notice to appear to your office. I believe your office was aware. Even based on the way you termed it, you say you didn't receive written notice, which we believe to the contrary because our records reflect that we sent you. The court itself sent you written notice, and then your office was aware, but you made a determination that notice that you seen or that you were advised of that stated it was a hearing on a motion was a control date. And that would be incorrect. It was not a control date. It was the date for a hearing.
No, Judge, I get the point that the court was making, but let me just make sure that the court is clear. My office did not get written notice. I believe that it was sent, but my office didn't get written notice. If they would have gotten written notice, they would have given me written notice. My office routinely reviews register of actions to determine if what's the status of the case is. And we filed an affidavit to that effect. My office manager said that she called Turnwall's office to see if there had been an order for me to respond to the motion for reconsideration. Judge, I've been at this for 43 years. I do not miss court dates. And I definitely won't miss a court date that's a Zoom court date that I know of. There's just absolutely no reason for me not to. But what happens is I have a staff that is a very professional staff, and they know full well that when it comes to motions for reconsideration, you better stay away from those because you can get in trouble if you respond and you didn't get a court order. But I hear what the court says. They wanted me to show up. I would have showed up. I'm sorry I didn't show up. If I had known, I would have showed up. The affidavit filed by my office, they state that they didn't tell me that they saw that on the register of action, and they wouldn't tell me because they're always looking at registers of action. But they know that if they get something in black and white, that there's a court appearance, they know to put it on my calendar, tell me about it, and Judge, just like this hearing, I'm here. And I understand what the court is saying, that they haven't received Mr. Greenwald's response. Well, I filed a response to his response.
There's no way as a attorney that I would believe that it's reasonable that your office, whether it's you or your secretary or your legal assistant, would see that there's a court date on a register of action, and we don't call the court to confirm if we didn't get a notice. Why would we call counsel? We would call the court. And based on what Mr. Turnwall is saying, that you called his office or your staff called his office and told him about when the date was. We have notice that was sent to both parties. I allowed Mr. Turnwall to give his reasoning on the record as to why he believed the court should reconsider. I don't even believe, based on those reasons, that I would have made a different decision if you were present.
Okay, that's fair enough, Judge. It's fair enough.
Yeah. I don't believe that would change or impact my ruling. And so I'm really, quite frank, I don't want to go into the back and forth with you and Mr. Turnwall on your beliefs as to whether or not this case should be stayed. I don't believe that you have properly sought a stay on this case. And that whatever you got going on over in the circuit court, there's been nothing that's been provided to me that shows me, or in the Court of Appeals, shows me that this case should be stayed, or that it has any bearing on the eviction at this time.
Well, Your Honor, if I may, and I'm right now, I've got to be careful, but I don't think there's any question that my clients have filed an appeal that is currently for the Michigan Court of Appeals. I believe the last time we were in court, you ordered my clients to be there, and my clients came to court, and we told the court that we were before the Michigan Court of Appeals. They've been making escrow payments. They're current with their escrow payments. And my understanding, and I can go back and look, Judge, is that this case was stayed, pending the outcome of the circuit court case. And that's why they're making escrow payments, and that's why they showed up in court.
But then we had a motion to reconsider.
And I get that, Judge. I do. Judge, I do get that. And Judge, the court was
okay. We'll let Mr. Turnwald speak now.
Okay.
Your Honor, once again, we're being misled. Mr. Fair's clients are not in the Court of Appeals. His appearance represents the occupants, the Davises. The parties in the Court of Appeals are not represented by an attorney. They're not the same parties. Also, the escrow amount is not been paid. If you check today, yesterday, the day before, it was due on the 15th. It's not been paid.
Okay.
Well,
I'll let you all continue to have your back and forth at your own leisure. I'm going to grant the order that was submitted under the 7-day rule, and I'll see you all at your next court date.
Thank you, Your Honor.
Okay. All right.
Thank you.
Thanks, Your Honor. Well, now, can I ask that if Brother Turnwald gets that order, that he email it to me, and I can assure the court I will have my office check every day to make sure that we have that signed order, because we have to file an appeal within 7 days, which I can assure the court that that's what I'll be doing, because there's a appeal before the Michigan Court of Appeals.
Okay, sounds good.
Thank you.
Mr. Turnwald will do that. Thank you.
Thank you.
On the record in the matter of Hamilton Road LTD versus Claude Miller, file number 23-01344 LT, counsel appearance.
Good afternoon, Your Honor. Gene Turnwald, on behalf of Hamilton Road Limited, my client is here in the court.
Good afternoon, Your Honor. Darwin Fair on behalf of the defendants, and I understand my clients are present in court today.
Who are you, sir?
Is that Tony Fair, Daryl Davis?
Is that you can have a seat there. Is that your client? No, you have a seat back there. I don't know who your client is, Mr. Fair.
Well, there's a number of them, and I'm not sure exactly which ones showed up, but if they identify themselves, those are the clients and the defendants in this matter.
Okay.
I'm one of them. Daryl Davis.
Daryl Davis is one of your clients?
That's correct, Your Honor.
Okay. Who are your other clients, Mr. Fair?
Yeah, Betty Miller. I understand that she is sick, and maybe there was a representative from her house who's there. If you could ask Daryl who else the defendant is there, because I can't see, Judge.
I'm not going to ask your clients who else is here. That's your job. That's why you were supposed to be here in person.
I'm the only one here.
I didn't ask you any questions. I just said I wasn't going to ask you. I don't know how you can represent and talk to your clients. You want me to discuss with your clients who's here? Should I go out in the hallway and check for you?
No, Judge, that's my client who's here. That's
I only have one person in the courtroom that I guess you're representing. I don't see anybody else here.
That's correct, Your Honor.
Okay, first, I think there was a motion that was received while I was away. States here, motion. Defendant's attorney ex parte motion for Zoom hearing.
That's correct, Your Honor.
Okay, so why are you filing a motion for a Zoom hearing?
Well, Your Honor, I am currently in Florida. That is where I spend my winters. And I don't plan to come back until Michigan until the spring. So it would be an undue burden on me and my clients for me to come to Michigan for one hearing and then go back to Florida. And I've been in Florida since last year. And I spend my winters in Florida. This is my 4th winter in Florida. And I have a thriving practice, and it's never been a problem in the past.
It's never been a problem in the past. I'm not following.
That I have to be in court while I'm in Florida.
Well, yeah, I don't know if other courts let you just hold evictions over until you come back to Michigan. I don't know how that's reasonable.
No, Judge, I do it through Zoom, just like during the pandemic. It's just been in my world, it's been a continuation of how it's been during the pandemic.
Okay, well, no, we do hearings in person. It's virtually impossible for me to conduct a meaningful hearing. I mean, you could even tell me if your clients were here today via Zoom. So how are you supposed to supposed to talk to your clients and get questions, and you on the record, they may have something that they want to share with you. They're in the courtroom, you're via Zoom. It prejudices your client if you attempt to run a hearing in that way. We can't even meaningfully exchange exhibits via Zoom. I don't like being talked over when I'm talking either. I don't hold hearings via Zoom. I don't care if you're a snowbird or not. This was set for in-person hearing. It's been set for in-person hearing. And you knew that the entire time. Did you talk to Mr. Turnwell to see if he would stipulate to an adjournment?
No, I did not.
Why wouldn't you do that?
Because every time I talk to Mr. Turnbull, it doesn't end up well.
Is there an objection to an adjournment?
Yes, Your Honor. Today's the day for the trial. We're here. This is for possession only. Your Honor has already ruled that Hamilton Road is entitled to possession of the premises. This case has been maliciously delayed for approximately 7 or 8 months now by a frivolous appeal, which is now in the Court of Appeals, and possibly may even be dismissed yet today. If not, it soon will be once again. And I have no doubt they'll take it to the Supreme Court. And it's simply for delay. We're asking for possession. The only occupant here is Mr. Davis. He is not a party to the Circuit Court case or the Court of Appeals case. He has no right to any stay. If he wishes to apply for a stay, it needs to be done in the Circuit Court or the Court of Appeals. There is approximately $4,000 that has been placed into an escrow account. This is an underpayment. The court has ordered $1,600 a month to be paid, and the $1,600 a month has not been paid. We'd ask that those funds be released to Hamilton Road as well.
You can respond, Mr. Chair.
Well, Your Honor, if I may, I filed a motion for clarification for the status of the case. The last time we were in court was in December the 19th. My understanding as a result of that hearing, that the court was already going to grant possession to the plaintiff. So that's why I asked for this motion of clarification for the status of the case, because my understanding of what happened on the 16th is the court has already made that determination. That's number one. The number two, what I had asked, Judge, is that if the court is going to grant possession to the plaintiff, that's fine. However the court wants to rule. Only thing I ask is that I can get a copy of the order because my client would appeal to the circuit court. In order to appeal to the circuit court, they have to have a copy of the order, and they have to appeal within 10 days. So
I've not made any ruling on possession. We've not had a hearing on that.
Well, I got a signed order saying that occurred on the 19th.
I don't have a clue why you got an order saying that. That's why this is set for hearing today. You should have got a notice of hearing. And the reason why we were having the hearing is for the issue of possession. We never addressed that. The only thing we ever addressed was a stay. And then we addressed escrow and that amount. I never granted possession. I've not even taken any testimony, any argument. None of that's ever happened.
Well, Your Honor, if I may, if you look at my motion for clarification, there should be an exhibit that the court signed on the 19th of December.
You talking about the order for motion for reconsideration?
Right, and then the rest of it indicates that it's going to have possession for the plaintiff. And that's why at that point, we were understanding that you had granted possession for the plaintiff. And only thing that we needed at that point was to appeal to the circuit court. So this hearing, we didn't see a reason for this hearing because we thought the court had already ruled. And
we never actually had a hearing on, we've not addressed possession. So if the order addressed possession or writ of eviction issue, that's an error because we've not addressed possession. What we addressed thus far, back and forth a lot, was the stay of the eviction proceeding. I said that I was not going to stay the case anymore. And so I said it for a hearing, and you were supposed to get your clients here. That's why today's date is set for two dates.
Yeah, well, and Judge, only thing I can say to this court is that is why I filed my motion for clarification, because after looking at that exhibit, it says.
But you did get notice of a hearing on termination of tenancy for today, correct?
Well, yeah, and that's why I filed my motion for Zoom. But
so you knew that we were coming today to address tenancy?
No, I did not know. I did not know. It says because I'm looking at your order.
Why did you file a motion? Then why did you file a hearing to have a motion to have the hearing via Zoom? You knew it was set for a hearing today for termination of tenancy, so you filed a motion last week, the 25th, to have that hearing held via Zoom.
Well, Judge, I also filed a motion for clarification.
That's not set for today. I don't see that on my docket.
I said it, and we did a notice of hearing for today. That was my notice for clarification because after I looked at your order, it says the stay is lifted and the application for writ for eviction shall be issued in 10 days. I mean,
I don't have any motion for clarification. The only motion I have here is the motion that I just addressed, which is your ex parte motion for a Zoom hearing. There's nothing in the file that represents a motion for clarification. Even if I just consider the fact that you filed this, it makes it clear to me. You said in your motion, you said on or about January 3rd, 2024, this honorable court scheduled an in-person termination of tenancy hearing for January 31st, 2024. So you indicate in your own motion that you understood what today's date was for. And then you proceeded to request to have this hearing by Zoom because you were in Florida. So I believe you knew what today's date was for. I see what your concern is as it relates to any misunderstanding in the court's proposed order that was submitted by counsel. It says something about the stay is lifted in an application and writ of eviction shall issue. That's an error. The court will have that addressed. The portions that the court granted was lifting the stay, and the court also granted the escrow order for $1,000, I think, from $1,000 to $1,600 per month is what the court granted. And that's been taken care, that's been being escrowed?
Some of it has been escrowed, Your Honor, not the full amount.
Okay.
Well,
And so your client is in the back raising his hand, and we can't do anything because you're not here to talk to him.
well, Judge, I can, if you want me to repeat what I said, I will, but I can only go by the information I have. And I do not understand why you do not have the motion for clarification. We filed it at the same time we filed the motion for Zoom.
May I, Your Honor?
Yes.
Mr. Fair is requesting, hoping, looking for an order he can appeal. And he thought he had one, and the order didn't show up timely. So let's give him the order he wants to appeal. Granted Hamilton Road possession and the escrow funds, and he has 10 days from today's date to appeal.
Okay, well, first I'm going to address the order that was signed on 19th. I'm going to edit it myself with my purple pen here, because that should not have been on there. And then I'll date that for today, that I have edited that portion of the order. As it relates to possession for judgment, today was the date and time that was set for a hearing on termination of tenancy. This matter was scheduled for an in-person proceeding, and we are ready to proceed. I don't believe you have any proofs that you intend to submit to the court, Mr. Fair. Is that correct?
Well, what we would submit to the court, and the court should have it in their record, is our defense to the allegations of the plaintiff, which is the lawsuit that was filed in circuit court and is currently in the appeal to the Michigan Court of Appeals. And that is the issue of quiet title and who actually owns the property.
Okay, who is the parties named in that lawsuit?
The parties named in that lawsuit are, if I could just, I'm pulling this up, Judge, as we speak. The parties in that lawsuit are Innovative Properties 1997 LLC, Matthew J. Brown II, Betty Miller, and the estate of Claude L. Miller.
What's your name?
Daryl Davis.
Okay, this person, the only person you have here is not even named.
This is.
No, he's a tenant who is currently living at the property that's owned by Betty Davis, who is, I understand, too sick to come up to the court. And she's also
someone just walked into the courtroom late in the middle of the proceeding. They said they're Matthew Brown.
Yeah.
The second.
Yeah, and he's a plaintiff in the lawsuit,
Okay.
Circuit Court, and
Gotcha.
also Court of Appeals.
Okay. Do you live at the address of? Sir, do you live, Mr. Brown, do you live at the address of? You do not? Say it so I can hear you.
No, I do not.
Okay. We're here for termination of tenancy. I don't deal with quiet title issues. The only person that you have here, the actual tenant, is not even the person who's a part of this other action. I don't have anything where you got from the court, or the circuit court, or the Court of Appeals staying any other proceedings pending their ruling on any matters that are remotely connected to this. I deal strictly with termination of tenancy. As it relates to that, tenancy will be granted in favor of the plaintiff because of your lack of production of any reasonable evidence to support why you should hold over the tenancy, or your clients should hold over the tenancy. So I will grant eviction in favor of the plaintiff.
Writ date, Your Honor.
What's the writ date? Today's the 31st, the 12th, but we have to go ahead and give them a couple extra days because they got to file that through OnBase and they'll kick it out. You can put it on for the 12th if you can get that filed through OnBase today. The issue is if it doesn't go through OnBase in enough time, I have to go and manually change the date. So as of today, the writ date is the 12th.
In addition, we'd like the escrow funds released to Hamilton Road.
Your Honor, I would like to address that.
You can address that.
Well, Your Honor, we are currently where I thought we were on December the 19th. And again, the court's ruling is fine, obviously, by me. Only thing we ask is two things. Number one is that we get a copy of that order because my clients do intend to appeal to the circuit court. And the only thing I can say to this judge is that this order was entered in December the 19th, and assuming that that was a termination of tenancy, we had until the 29th to appeal. That order was not even mailed to us until January the 3rd. And if you had my motion for clarification, you'd see a copy of it. And I believe Brother Counsel has a copy of it. So it wasn't even mailed out to me until after the 10 days. So only thing, and Judge, if you get a chance to read that motion, my office called the circuit court. We looked at the register of action. We religiously did everything we could to get a copy of that order within the 10-day period. But it wasn't even mailed to after the 10 days. So if the court's going to enter an order, I would ask that it be emailed to me, faxed to me, so we can get a copy of it within the 10 days, so that we can appeal.
The order's going to be filed electronic. We have an electronic filing system.
Oh, absolutely, Judge.
For civil matters.
Absolutely. So then we'll get it within the 10 days. So that's number one. Number two, if a possession order is entered, the tenant has a right to appeal and for escrow order to be entered. And so counsel is not entitled to the escrow. That is something that would happen after the appellate process occurs. My clients.
But if he appeals, is what you're saying, but he has not appealed yet.
Yeah, but Judge, I've already been retained to appeal. They are going to appeal. Just like
I recognize you've been retained to appeal, but being retained to appeal is not the same as being appealed. It has to, appeal must be filed before you can assert that right. It can't be an intent to appeal.
Well, yeah, and you're absolutely right, Judge. But the fact that they appealed to the Michigan Court of Appeals, that's a good indication that they are going to appeal. And as soon as I get that order, Judge, I will file the appeal.
And that's marvelous. And I don't know how, good luck to them sorting all that out. That's not for me to sort out. But the tenant, and this is a termination of tenancy matter, is not a party in the other matters.
Yeah, and I get that. But the point being is that we intend to appeal the termination to the circuit court within the 10 days.
Okay, well, you can appeal the termination if you want, that's fine. But what I'm saying is that this tenant is not a party in any other matter. Technically, if you ask me, I think it's even a conflict for you to try to represent the owners and the tenant. I think that's somewhat of a conflict, but that's for them to decide if they want to waive that conflict. And apparently they have. But again, the only person I have here is one person that says they live in the property, another person who doesn't live in the property, doesn't have any name, a stake in the possession or the tenancy issue. That Mr. Brown, I'm assuming, is a party to the title action, the quiet title action that's before another court. I don't deal with that here.
And that's fine, Your Honor.
Okay, so once we get the signed order on base, then and you should, I'm assuming, have a electronic MyFile account, correct?
Yes, I do.
Okay. Okay, so and I see here where our last order was mailed to you on the 3rd, and that's probably because that's when I signed it, or around the time that I signed it. It wasn't signed just because we had the date of the hearing that day. And again, with the new filing system being the way it is, things have been much delayed during the holidays. Our civil department's even closed 2 hours a day trying to catch up. That none of those things should prevent you from being able to file whatever appeals you feel that you want to file. We'll make sure that order is filed by the plaintiff, and the court will review it and sign it.
Your Honor, I'd like this order to.
No, Judge, I haven't finished. I haven't finished. There's just one other thing that I am a little concerned about, is that you don't have a copy of our motion for clarification, because we filed that through the system also. So I'm not sure what we have to do on our side to make sure you get copies of the pleadings that we filed. And if
there appears in my file, there is a motion in there. It's not in my physical copy or file that I have here. The only thing that was on my desk physical when I got here was the motion to address your Zoom hearing. And that's the only matter that they set for a hearing today. They didn't set the other matter for a hearing. Outside of that, it's really a moot issue, because the court just already addressed the issue, which was when Mr. Turnwell filed his proposed order, which is the order for a motion for reconsideration, which was filed under the 7-day rule, and you had an opportunity to review and object. There obviously was an error there. The court has addressed that error. You could have and should have caught that error under the 7-day rule, but for whatever reason, that didn't happen. And then also, based on your motion, you knew that today's date was set for a termination of tenancy hearing. So I don't believe that you believe that there was a ruling on that if we had a hearing. It's unreasonable for me to think that you think that we've addressed that if you're asking to have the termination of tenancy hearing via Zoom.
No, Judge, I just, I think part of the problem is that you have not read my motion for clarification. And what concerns me is I'm filing motions and they're not getting to you, Judge, the most important person. I've heard your rendition of the facts, but I think if you had a chance to read my motion for clarification, you would view this, what I'm saying, a little differently than the way you're viewing it now. And the only thing I'm saying, Judge, is I'm filing motions, they're not getting before you, and then you're having a half look of the position that we're taking. But having said that, the only reason I brought this up is because when I'm filing motions, they're not, for some reason, getting to the court. That motion for the Zoom was also filed.
How many motions have you filed that's not gotten to the court?
Oh, okay. With regards to the motion for reconsideration, that didn't get before the court.
Your motion for reconsideration did get to the court. It's in the file.
The response at the last hearing, you said you didn't have it.
No, we got a motion for reconsideration. I don't know about another response that you filed, but that wasn't filed electronically.
No, that response, the response we had for their motion for reconsideration, when we were at the hearing on the 19th, you said you didn't have it. And we filed it. I mean, I spend time working on these briefs, and then and I file them, and then you don't know about it.
I don't know. Maybe the mail goes longer from Florida. I don't know. I don't know why it didn't. That
Your Honor,
wasn't here.
it didn't make it to your court file because he never set a hearing date for the motion for reconsideration. I mean, for the motion for clarification. There's no hearing date on it.
I just told you that it's not set for a hearing before me.
And the other problem was when he filed his responses to my motion for reconsideration. The court rule doesn't allow a response to the motion for reconsideration. And also it was improperly filed and the court clerk system rejected it.
Well, that's not exactly what happened, Judge. And so we don't keep going back and forth.
I don't want to go back. That's the last thing I want to do on this case any further. I have spent all the time on this case I ever would like to spend on an eviction case. This matter has been pending before me, and I've been looking at this file since June, before you were in Florida. And so now here we are in 2024. I've made my ruling. You now have the order that you need, or you'll get the order that you need so that you can process whatever appeals you want to do for your client as it relates to termination of tenancy. Any other matters for today?
The order should, I'd like the order to reflect that Hamilton Road receives the escrow funds. And if they truly do appeal it, simply address a new escrow order at that time.
Yeah, the escrow funds will be released to Hamilton Road unless there is a appeal filed. That's
right, exactly. Right, exactly.
Okay. Thank you.
That's what the law says.
Any additional matters for the record?
I have none, Your Honor.
I am preparing an order and I will hand it to you.
Actually, we need your order filed electronically.
Okay, thank you.
Thank you. You're all set for today.
Well, if you send me the order, I'll sign off on it.
I prefer that.
Yeah. So Turnbull, why don't you send it to me and I'll sign off on it, and so there won't be any issues before the judge.
No, we've been down this road. Where are you? What is your address?
You're welcome to come down the
what city are you in now?
Can you email it to me?
Sure.
My email is the same. Right, and I get correspondence from courts all over, Judge. And I get correspondence from lawyers all over. They send it to my
Sounds
email.
good. Yeah, I agree that you can get it by email.
Right. Okay.
That.
Your Honor, my boss, my secretary says he won't sign it today, so therefore we can't enter it today.
What do you mean?
Why wouldn't he sign it today? Well, Mr. Fair, if you receive it today, will you sign it today?
Absolutely, Judge.
Wonderful.
Okay, thank you, Your Honor.
All right, you're all set. They'll send it to you via email.
All right, thanks, Judge.
You're welcome.
This matter is closed. I can leave.
It's closed.
Okay, thanks.
Thank you.